Thank you, Lascan Corla. And first of all, can I welcome back the Minister? It's great to see you, and every happiness to you and your new family. But down to work, as you know, straight back with a bang. I suppose, for me, actually, one of the most interesting things about this bill is that very few constituents have contacted me specifically about it. Yes, there's all the ongoing issues, but because this bill has such an impact on so many people, I was really surprised that more people didn't contact me. So the truth is, whether you own commonage on the Ox Mountains or you share a back laneway access to your home in one of the smaller towns in my constituency or your constituency or Deputy Pringle's constituency, whether you have fishing rights or whether you have a right to light, whether you have turbary rights or the right of way across your neighbour's land to access your own land, rights to water or access to sewer pipes through a neighbour's land. The Conveyancing Law Reform Act of 2009 is hugely significant for most of those people. Yet, with the exception of a few people, so many others were blissfully unaware of the freight train that was heading down the tracks straight at them. Not everybody, but anybody and everybody who relied on prescriptive rights, easements, profits apprendre, which of course allow you to take produce from another's land, let's say like turbary rights or fishing rights. Anybody who relied on those rights as a consequence of a gentleman's agreement or a gentlewoman's agreement, simply doing, in many cases, what they've always done and what maybe their fathers and grandmothers did, without validating or registering those rights. All of those people could be facing, in many cases, possible court cases, protracted legal wrangling, delays by banks to grant mortgages, delays by solicitors in sorting wills. It was a recipe for disaster. Didn't impact everybody, but it did impact many people. And what I found really astonishing was that so few people were aware of it. In fact, Minister, I was unaware of it until this legislation was introduced to the Seanad. And we're all aware that this legislation was a recipe for disaster. Not just the potential, but we know in many cases the certainty of the spectre of neighbour versus neighbour. Now, today's work is urgent because basically we are repealing those parts of the 2009 legislation that would have led us into a legal quagmire with extortionate costs and never-ending delays. So in that context, we're doing a good thing. And claims made after November 30th will be dealt with in basically the same way as those made before the 2009 bill. There are some changes, but nothing major. So I think what we're attempting to do today is not to fix the overall issue, because many of the issues that arose pre-2009 still remain. But we are trying to prevent the creation of further problems that would have come about because of the 2009 legislation. The circumstances surrounding access to land, rights of way, in both, people think this just affects rural areas. It affects urban areas just as much, and many colleagues have alluded to that here today. And it's not just private land, it's public land. But all of those issues are hugely complex. I don't pretend to understand the legislation or indeed all of the issues, but we do know that some agreements go back generations, often, as I said, with no formal documentation, gentlemen's or gentlewomen's agreements. But when those agreements were made maybe 100 years ago. It can now be very tricky to establish that right. People want to do the right thing, but equally, they're very concerned around ownership, and that if they grant formal rights, or if they grant rights formally, that might dilute their ownership and their ability to sell or lease their land. So in that context, Minister, I'm pleased to hear that you are setting up a time-bound review to establish any further changes that are desirable to the law on prescriptive easements and profits. However, I, like many other deputies here, have real concerns about the rushed nature of this part of the process. Yes, there's been widespread consultation with stakeholders, and I've no doubt a lot of time and effort has gone into producing this draft repealing legislation. But in my view, and that of several other speakers here, the assessment of this legislation by this House, and we're part of the process. Sometimes it might seem as if we're separate to it, but we're part of it. The assessment of this legislation by this House has been rushed. Yes, it's urgent. Nobody disputes that. But surely the fact that we are eliminating the flaws in 2009 legislation, and hopefully all the flaws, shows the need for proper due process in this House. That doesn't guarantee success, but it just moves it up a notch. And the truth is, Minister, you know, this is our role, this is our job, to make our contribution to amending or shaping legislation. You may or may not take it on board, but that's our role. So it's not just a rubber stamp. And of course we will do as expected and support this legislation. But we do so under pressure and in a hurry. And I think we would all agree that's not a good way to operate. Now, having said that, can I say I support the proposals, the repealing proposals in this bill, as it will make a difference to so many people, even though they don't know it, and maybe thankfully many will never know it. But one issue I want to raise is my real concern about the fact that the requirements for an individual to establish prescriptive rights, easements or profits on state land is much more onerous than on private land. Now, my question to you, Minister, is why is this? The state is a juggernaut. You know this, I know this, and those who don't know it are in for a rude awakening if they take on the state. I believe that the rationale for this, and I've read the documentation, and it says that it is more onerous for the state than for a private owner to be aware of any easements or profits being exercised against its lands, particularly regarding foreshore. I just don't buy that, Minister. Don't anybody try and tell me that anything is more difficult for the state than it is for an ordinary individual. And if even initially an unexpected claim is made against the state, the whole apparatus of the state, and I've described it as a juggernaut, and that's what it is, that is there to defend its, and yes, our interests. Therefore, I don't support the premise that the state needs greater protection than the ordinary person. We have often heard of competence creep when it comes to institutions attaching greater powers to themselves. Well, this, in my view, is possession creep or acquisition creep, call it what you like, because when it comes to rights exercised on state lands, it's much more difficult, considerably more, for an individual to establish easement or rights. And I have a real issue with this. And the rationale that has been provided in the documentation that I have received doesn't satisfy me in any way. Now, finally, Minister, I started by referring to the fact that surprisingly few people, not, of course, some people contacted me, but surprisingly few people contacted me about this in recent times. And this tells us clearly that we do need an information campaign, and not just for the general public, but also for everybody concerned in the legal profession as well, whereby those who deal with this matter and those who are affected by this matter are aware and fully aware of how either current or impending legislation can significantly impact their lives and the rights that they exercise on property other than their own. So, Minister, I support this bill as a necessary first step, as an essential first step, but we do need to see evidence of ongoing work to streamline, where possible, the current legislative framework, and we need to ensure that the general public are fully aware, insofar as we can. Not everybody will be fully aware, but there needs to be a proper awareness campaign so that people have a sense of some of the implications of any legislation, this or any future legislation that we pass in this House. Finally, Minister, and again I suppose it tells us about the rushed nature of this legislation, and I just simply haven't had time to look at the issue of seaweed rights, and I know my colleague Thomas Pringle, Deputy Connolly and others spoke about it, and it's a matter when, as a member of the European Parliament, I was significantly engaged with. And I did hear Deputy Pringle saying that he was reasonably satisfied, I think, with some of the proposals in the legislation. I need to have another look at them, but this certainly is a matter that needs to be dealt with as soon as possible. So once again, Minister, welcome back. Thank you.